matter of Geraldo versus Gultierrez. Ms. Gultierrez, are you attempting to appear by video or just by telephone?
Just by telephone, yeah.
Okay. Well, I need you sworn in. The other party was already sworn in. Please raise your right hand and answer verbally when you've been given the oath.
You got it.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, thank you. So this matter is on initially for 2 motions for order to show cause filed by Mom. In the interim, there were oppositions and counter motions filed by Dad. Frankly, and I'm sure Judge Gentile has made this observation, the voluminous filings make it very difficult to keep track of even what the court is supposed to be addressing at any given time. And neither of you are doing yourselves a favor under those circumstances. I'm going to set some ground rules in your case. This is our first time dealing with one another. And you all need to understand the court's expectations so we can move forward from this point. There are a very limited number of things this court is authorized by rules to do ex parte or will do ex parte. I can extend time, shorten time, issue orders to show cause regarding contempt, and continue hearings. But given the history of this case and the overwhelming amount of litigation, nothing will be done ex parte in this case. So please no longer submit ex parte requests for relief, sir. Secondly, there are page limits and type volume limits set forth in 8th Judicial District Court Rule 5.504 subsection E, and the parties need to abide by it. If you need a copy of it, my assistant can send it to you, but you're representing yourselves and you're expected to know what the rules require as far as your pleadings. If you submit a document, for example, with more than 1,300 single-spaced lines of text, it is not a valid submission. The court will strike pleadings that exceed this limit going forward, as I'm permitted to do by the rules. I don't need a recitation of the entire case, and I certainly don't need a rant berating the court for its prior orders and continuing to degrade one another with respect to your behaviors in this case. Both of you have behaved deplorably. Judge Gentile has made very clear orders. That's what this court is bound by. That's what the 2 of you are bound by. Whether it's me or any other judge reviewing this case, the findings leading to the current orders and the orders themselves control the current circumstances. In that regard, Judge Gentile also gave very clear directives regarding when and under what circumstances modifications to the existing orders will be considered. And that is true whether it's a request to expand contact with the child or request, yet again, supervised visitation for the mother. The court made clear orders. If you are confused, see the minute order December 11th, 2020. The current order states, Mom has unsupervised visitation every Saturday from 10 to 6. Dad or his wife are to provide the transportation. This decision was made on full information by Judge Gentile and was not appealed by either party. That's the recourse if you think the court has made a mistake. You file an appeal and have another higher court review it. The current request, Mom asked to clarify whether the April 20th order included ongoing compliance with the previous holiday order. It did not, and it will not. And to be clear, all of Dad's references to 432B are inapplicable. That is not the law that governs this case, sir. It's Chapter 125. It's the custody statute. 432B applies to when the state is involved in instances of abuse and neglect and the child has become a ward of the state. Hopefully we never get to that point. So with regard to the order to show cause for missed visits, because the missed visits are primarily concerned with holiday visits, the court does not find that there's a basis to consider further contempt. Are you clear, Ms. Gutierrez, that there is no holiday visitation? Your visitation consists entirely of Saturday from 10 to 6.
I do understand.
Okay. Sir, you were ordered on October 5th to submit to a hair and urine test, and there is no record at ATI of you submitting to that test. Did you? Yeah, I'm sorry, sir. You're muted. We do it all the time. Can you unmute yourself?
Yeah, can you? Okay. So I had my employer send over my test, and I thought that was going to be sufficient.
No, you raised that issue at the time of that last hearing where it was ordered that you submit to a hair and urine test. That is not sufficient. You are to go by 5 p.m. today. And to be perfectly clear, your failure to submit to the test is going to be considered a positive drug test. And then we'll deal with that. Is there any reason you can't go by 5 p.m. today?
No.
Okay. That's the expectation. And again, the presumption will be that it's a positive test if you fail to comply with that order. That is the order that's been violated. The courts look through the remaining of it and is not going to, as I stated, pursue contempt. All other requests are denied. I do believe that there was an intention of Judge Gentili to order child support, again, with the voluminous and multiple filings, things like that. Very important things get lost, right? When you're trying to review 10 different documents asking for 10 different things. So if the parties are still asking the court to consider child support, and under the circumstances, it's certainly warranted. I wouldn't fault anybody for requesting a review of child support. I need updated financial disclosure forms, particularly now that you're working, sir. Have you received your first paycheck yet? Directed to you, sir. I'm sorry. We lost you for a minute.
Okay.
Did you receive your first paycheck yet?
Yes.
Okay. So provide updated financial disclosure forms, attach your most recent pay stubs. I'm setting this on what's called a chambers calendar. You've dealt with those before. The court is going to review the results of the drug test and review each party's financial disclosure forms, and the order that will result will address those two things. My intention is to avoid any further proceedings. If the drug test is negative, then there isn't a need to have further proceedings, and I will just issue an order that acknowledges that and makes an award of child support if warranted. The date for the Chambers calendar will be April 16th at 1:05 a.m. That's how you know you don't need to be here, because I won't be here. And I believe that addresses everything today. Thank you both. All I have.
You. Your Honor.
Thank you.
Alrighty, we are done till 1:30.